So you understand that I can give you anything from probation up to 24 months, up to 2 years on each of these cases,
Mhm.
and I can stack those sentences on top of each other. Do you understand that as well?
Yes, ma'am.
And you want to go forward with these pleas and get the sentencing on these done. Is that correct?
Yes, ma'am.
In addition, Your Honor, my client has asked, and I know the response to the court given the prior answer, but I am required to ask this court. She's asking the court waive pre-sentence investigation on these and proceed with sentencing. She also would like to be released for her, I believe it's daughter's graduation.
They said it for weeks. Stay posted.
No, that's not happening. All right. And I'm definitely not going to waive the pre-sentence report because I want to make sure that it's just the ones, if there's any other history, obviously there's a substantial amount of history. And so I want all of the information. So we will get um, a pre-sentence report done in all of the cases. And I'm not doing anything with the bond other than potentially raising it to make sure that we're where we need to be when we need to be. So
In the courtroom of Judge Raquel West, silence can be louder than any excuse. Today's defendant, Rebecca Rido, isn't a first-time offender. Her record spans more than a decade. Theft charges in 2010, 2015, 2021, and now 4 new cases in just 2 years. No plea bargain, no deal, just guilt and consequences. As her attorney asks for leniency, Rebecca makes one last emotional request, a chance to attend her daughter's graduation. The judge's reply cuts through the courtroom like a blade. No, that's not happening. In this moment, justice shows its boundaries, calm, firm, and absolute. Because inside this courtroom, mercy is earned, not expected. This is the reality of justice. This is Court Beyond. Let's dive into the video.
all right, you're Rebecca Rido, and will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
That's good. Ms. Rido, in cause number 23 DCCR 0928, you're charged with, hold on, if y'all want to print those other ones, it might be convenient. The next three, 210607 and then 1925. All right. In this case, which is 23 DCCR 0928, you're charged with the state jail felony offense of theft of property with previous convictions from November 21st to 2022. The indictment alleges you were previously convicted of theft September 11th, 2010. I'm sorry, September 17th, 2010 in 2 different cases. And then again, October 26th of 2015. And then September 21st of 2021 in 3 cases on that date. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are all those prior offenses and convictions true?
Yes, ma'am.
And then in cause number, say printing, or do you want me to pull it up? In cause number 23 DCCR 2106, you're also charged with theft of property with previous convictions. The offense date from this one is September 23rd of 2023. It alleges those same prior offenses. And how do you plead to that charge?
Guilty.
And are those prior offense convictions true? And did you enter your plea of guilty freely and voluntarily?
Yeah.
And because you actually did what they charged you with?
Yes, ma'am.
And actually, that indictment, I said the 23rd day, it has been indicted, it has been amended that the offense date is the 22nd day of September. Does that sound correct? Okay. And then in cause number 23 DCCR 2107, you're also charged with theft of property with previous convictions from October 2nd of 2023. That indictment alleges those same prior offenses. And how do you plead to that charge?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are all of those prior convictions true?
Yes, ma'am.
And then finally, in cause number 24 DCCR 1925, you're also charged with the state jail felony offense of theft of property with previous convictions. This is from June 13th of 2024. It alleges those same prior convictions of theft. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with.
Yes, ma'am.
In each of those 4 cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And it's my understanding you have no agreement in your case, in any of these 4 cases. And so you're just pleading open to me. Is that correct?
Yes, ma'am.
I want to make sure you understand your cases are set for trial. To begin with jury selection next week, you have an absolute right to have a jury come in and decide if you're guilty or not, and then to decide what the punishment is if they find you guilty. If we go forward this way, you're leaving that up to me. And is that what you want to
Yes,
do?
ma'am. Sorry to interrupt. The state has filed a motion to accumulate. We will be asking the court to accumulate those cases to the extent the law.
Okay. Because they're all different offense dates, correct? Or at least
Some of them.
I don't think they are. Nope, they're all different offense dates.
We will be asking the court to accumulate those sentences.
And have you gone over that with your client?
Yes, Your Honor, she's aware that the state's asking for charges to be stacked.
I guess part of my issue with this is, about let's say I do something that Miss Rido doesn't like, and then she has the ability to appeal, and I don't guess there's really an appealable matter, but you never know. I don't want to waste a bunch of time and then us be coming right back here, but
And Judge, I've looked for the path of least resistance to resolve these cases that we are in the situation we're in because
no, I don't disagree. Well, we'll get where we get. All right, so you understand that I can give you anything from probation up to 24 months, up to 2 years on each of these cases, and I can stack those sentences on top of each other. Do you understand that as well?
Yes, ma'am.
And you want to go forward with these pleas and get the sentencing on these done. Is that correct?
Yes, ma'am.
In addition, Your Honor, my client has asked, and I know the response to the court given the prior answer, but I am required to ask this court. She's asking the court waive pre-sentence investigation on these and proceed with sentencing. She also would like to be released for her, I believe it's daughter's graduation.
They said if it was stay posted.
No, that's not happening. All right. And I'm definitely not going to waive the pre-sentence report because I want to make sure that it's just the ones, if there's any other history, obviously there's a substantial amount of history. And so I want all of the information. So we will get a pre-sentence report done in all of the cases. And I'm not doing anything with the bond other than potentially raising it to make sure that we're where we need to be when we need to be. So that being said, do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each of those cases. Is there any evidence that Ms. Rido is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty and true in each of these cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. In each case, I'm going to find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your cases, and then we will come back at a later date for sentencing. And then I will number the tampering case for trial next week. Obviously, it's fairly new compared to some of the other ones, but it looks like a lot of them are getting taken care of this morning. So you never know. You guys will know today after docket what the trial order is.
One final thing on temporary judge, it's filed as a third degree, but I filed a repeat bitter notice seeking to enhance it to the second degree, given the defendant's previous robbery conviction. So I just We'll make sure that all that's.
Why hadn't you put the tampering on me when you put the death on me?
Look, we're not, this isn't a conversation.
I'm sorry, it's me.
It doesn't matter. And they didn't put anything on you.
I mean, that's what I'm saying.
Okay, listen.
I don't understand how it's a tampering. I mean,
That's what juries are for. If you don't, Mr. Wilkerson has gone over it, I'm sure, with you. He has his position legally. You know what the options and what the consequences are in that case. In that case, if you go to trial and you're found guilty, and there is a prior robbery conviction, it's important that you understand that the range of punishment then becomes that of a second degree felony, which is between 2 years and up to 20 years. Do you understand?
yes, ma'am.
Okay. And so I will number that case for trial for next week. All right. You can go back with the bailiff.
Thanks, Judge.
Thank you.
After hearing the series of theft cases, the docket moves on to a new matter. This time, a quiet but firm example of accountability. The next defendant, Chase Bro, stands before the court charged with unauthorized use of a vehicle, a state jail felony under Texas law. There's no argument, no confusion, just a simple question and a straightforward answer. Do you plead guilty, freely, and voluntarily? Yes, ma'am. For Judge West, the lesson is clear. Responsibility doesn't depend on the size of the crime, only on the truth of the choice. Let's watch as this quiet exchange delivers a powerful message about justice in motion.
Good morning, sir. You're Chase Bro.
Yes, ma'am.
And Mr. Burbank, will your client waive the formal reading of the indictment?
Will not.
Mr. Bro, in cause number 2240132, you're charged with the state jail felony offense of unauthorized use of a vehicle from May 17th of 2022. And how do you plead to that charge?
Yeah.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And why is there a difference between the rejection and what we've got today?
Your Honor, this is a case that, in all honesty, we shouldn't. I am of the opinion that we shouldn't be using or wasting the jury on unauthorized use of a vehicle case. In this take responsibility given his criminal history, I think 180 days is sufficient. I'd much rather focus on the rape to losing verbs. Try the
I don't disagree. I just think we need to do that when we do those rejections. All right. So do you understand, if I follow the agreement that you've made with the district attorney, you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm required to ask everyone that. State tenders number 1.
No.
It's admitted. Is there any evidence that Mr. Bro is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of unauthorized use of a vehicle, sentence you in accordance with your agreement to a term of 180 days in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes, ma'am.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm.
Yes, ma'am.
If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Burbank. All right, good luck to you, sir. Thank you, Mr. Coleman. Thank you, Mr. Burbank.
The morning in Judge Raquel West's courtroom ends with 2 outcomes. Both clear, both final. Rebecca Rido, a repeat offender, leaves the stand knowing her record will follow her into sentencing. 4 theft cases, years of prior convictions, and no more chances. The judge denied her request for release and ordered a full pre-sentence investigation. For her, the next time she walks into this room, it will be for judgment. Chase Bro, on the other hand, accepted responsibility the moment he spoke. 1 felony charge, unauthorized use of a vehicle. No argument, no hesitation. He received 180 days in state jail and lost his right to possess a firearm. 2 defendants, 2 different paths, but both met the same law and the same judge. In this courtroom, guilt and accountability are not about scale. They're about truth. Justice isn't loud here. It's precise. This is Court Beyond.